Good afternoon, everybody. My name is Jeff Newby, and this is my partner, Alan Arsenis, and we're here live today in our Mount Laurel office of Weber Gallagher, and we're here to present the next series in the Weber Gallagher series for education at WG University. And we do this every month. We rotate states from New Jersey, Pennsylvania, and Delaware, and we try and give you some updates on the law, some strategy on how to minimize your risk, and we present both updates and current topics as well. If you'd like to watch this webinar again or share it with your colleagues, you can go to the WG University programs. Just go to our website, wglaw.com, and you'll find copies of the presentation. You can view it in the future as well. Also, if you have any questions, you can send your questions to questions@wglaw.com. All right, so today we're going to be talking about updated case law in the last year in 2017. We've got a top 10 list with a bonus that Alan has for us. And again, we'll try and blow through it because we know everybody's busy during the holiday season. So Alan's going to start us off.
First case involves a jurisdictional issue between New Jersey and New York. In this case, which is captioned Williams versus Reymore Furniture Company, the petitioner completed an online application for employment with the respondent. The respondent actually called the petitioner at his home in New Jersey to arrange for an interview in the home office in New York. He attended the interview, and sometime thereafter, the respondent called the petitioner at his home once again, offer him a job as a warehouse man. That call took place to the petitioner's home. He answered the phone, he accepted the job, and he started his employment. A couple years later, in 2014, he suffered an injury where he fractured his elbow and started to receive medical and wage loss benefits in New York. About a year after that, he filed a formal claim petition, and the respondent answered the claim, filed a general denial, but also raised the affirmative defense of lack of jurisdiction. The trial court dismissed the petitioner's claim with prejudice, noting that everything basically took place in New York except for the residency of the petitioner who resided in New Jersey. The judge concluded that there was no reason for New Jersey to have jurisdiction. The issue presented in this case is whether there was appropriate jurisdiction in New Jersey. Up on appeal, the Appellate Division reversed the trial court's decision and noted that the formation of a contract actually occurred in New Jersey by way of that call. As a result, the case was remanded for further findings. The reasoning of the Appellate Division was they basically look at the grounds of establishing jurisdiction. There are 6 grounds in general, but the one and the important one in this case was the fact that the contract of hire took place in New Jersey by the fact that there was a call to the petitioner's home, he accepted the employment offer, and began working. So when you are looking at jurisdiction, there's many factors to look at, but if you call a petitioner out of state, offer him a job, he accepts it at his home, whatever state that is. In New Jersey, at least, jurisdiction is conveyed. In most states, they do follow the same reasoning. So obviously, it's probably better to bring him back into the office to offer him a job, so to avoid multi-state jurisdiction in situations such as this.
You know, that's what I was thinking. You know, oftentimes they have sometimes the initial meeting will be at the employer's office, but that phone call changes everything. And I don't know about you, but recently I discussed this issue with clients sometimes at functions, and I talk about, you know, the site of the contract of hire and the old language from old case law. The state of the contract of hire is where the acceptor is speaking when they accept the job offer. But I was quoting that from old case law from decades ago, and now we've got a 2017 case that says the exact same thing.
It's still the current case law, and that's why you just have to be careful. I know it's an inconvenience to bring a person back out of state once again to your place of employment, but in situations such as this, it would have been more advantageous to the employer to avoid the multi-state jurisdiction.
Yeah, because you know, everything else being New York, you know, you kind of like the judge's decision. And what I didn't like was the 6 factors, this 6-factor test, because I've never seen 6 factors before. They usually talk about the site where the injury took place, you know, if they regularly work out or from New Jersey, if they live in New Jersey and were hired in New Jersey, things like that. Exactly. But some of these other issues, a place where the industry is localized. If the petitioner himself doesn't have any contact with the place where the industry is localized, what difference does it make where the industry is localized? What's the petitioner's contact with the state?
I don't necessarily agree with all the factors, such as where the employee resides. That in and of itself is not enough in New Jersey. So I disagree with that one particular factor that they applied at the appellate division. So it just goes to show that the appellate judges, even though they're a little bit more learned, they're not always right.
Right. And I think that the place where petitioner resides is just going to be a factor, because case law has always said that is not enough. Where you choose to live, you want to live in South Jersey and go over the bridge to Philadelphia. You want to live in Hoboken and go over the bridge to New York. Residence alone's never been enough, and I don't think this case really changes that. I think it's probably just one of the factors they throw in there.
Exactly.
So the next case we wanted to talk about is an on-call case or an off-premises injury case. These cases are always interesting, and the fact patterns are interesting, and you need to know these cases and the fact patterns in order to match it to your particular circumstance. And this one doesn't disappoint us. In this case, Liu versus 4D Security. Mr. Liu works for 4D Security as an engineer, and he was sent by his employer to work in the United Arab Emirates to test out some hardware. On the day of his injury, however, it was a Friday, he wasn't working. He had the day off, and he went to a museum to sightsee. So he's at the museum, but he has his, he says he's on call, and he has his BlackBerry. And I'm thinking, what's the year of this case, 2011? He has a BlackBerry? What's up with that?
That's definitely
I thought everybody had an iPhone by 2011 or something, but not a BlackBerry. But anyway, he brings his BlackBerry with him. So now he says, well, I'm on call, and I'm going to the museum because I want to get into this culture. And I want to get to know the people and what they think. And so, he's just fluffing up a lot of stuff to try and get to the other issue that he's saying is, one, I'm on call, and two, my injuries are due to the mutual benefit doctrine. I'm here for me, but I'm here for my company because I'm going to understand their culture by going to their museum. While he's at the museum, he falls, he injures himself, and he has surgery. So the issues are the injuries compensable? Do they arise out of and during the course of employment? Is there a special mission, mutual benefit doctrine? For every argument, it's just thinking they're trying to get benefits. So the holding was the claim was denied, both at the judge and appellate level decision. The petitioner's cases that he argued were all old cases where the on-call status. If you're on call 24/7 and you're injured, you can be covered by workers' comp. The cases that he was using and his attorney argued were all pre-1979. So what's the significance of pre-1979? Well, what happened in 1979 was the statute was amended and Section 36 was promulgated to try and limit off-premises injuries. You're only going to be covered for off-premises injuries if you're furthering your employer's business interests. So that was the focus. So the cases that he relied upon pre-1979 were a bit more liberal because jurisdiction was being found and compensability found for a lot of off-premises injuries. So what the court said here is when he was off-premises, he was not furthering his employer's business interests. The idea that he was trying to get to know the culture of the United Arab was not enough for the court to find that to be mutually beneficial. This was really a sightseeing trip. And when I read this case, Alan, I'm not sure if you'll remember the case from, it's probably a decade or so ago at least, where the guy was in Australia.
It's in the same case, yes.
Unbelievably. This guy's in Australia, and he goes there, and not only is he there for a business trip, but his company wants him to relocate and live in Australia. They're hoping that he likes it enough that he'll move his family around the world. And he says, I'm going to go sightsee, and they encourage that. Go see places, get to know Australia, and hopefully he'll be enamored enough with the country that he'll live there permanently. Talk about mutual benefit. He fell while he was on a sightseeing trip, and he didn't prevail. If he didn't prevail, this guy's not going to prevail.
Very good point.
All right, next case, appellate review. We'll talk about some appellate review of the judge's decisions.
This case, as Jeff said, is about appellate review. In this situation, the petitioner had a prior accident in 2007, ultimately settled for 35% of partial total. He reopens it in 2013, and initially the respondent was seeking to do a Section 20 resolution because they were saying that there was no change in the medical evidence to establish an increase in disability. The trial judge refused to approve the Section 20, and the case proceeded to trial.
And, we underlined that refused to approve the Section 20 for a reason. You guys, we all want Section 20s. We all want Section 20. We try and get them for you as well. The judge has to approve it. It has to be fair, just, and reasonable. That's why we underline that. The respondent in this case wanted this case closed with prejudice. The judge decides whether or not they're going to approve it.
And unfortunately, there's a lot of liberal judges out there that are so adverse to Section 20 dispositions. It's extremely difficult to get them to agree, and oftentimes you have to have an absolute slam dunk winner to get them to approve Section 20. In this case, anyways, at the trial, the workers' comp judge found that the employee's testimony with respect to increased complaints was believable, and that his complaints were of a severity to be warranting of an increase in disability. Also, their expert corroborated his testimony that there was evidence of an increase in disability. So the judge concluded that he established a 10% increase and awarded that increase in disability. The issue on appeal was, did the trial court commit an error of law establishing a basis for appellate review? The holding, the appellate division affirmed the lower court's decision that the petitioner established an increase in disability. In their reasoning, the court cited a long-established rule that when looking at the trial judge's decision, the court must determine whether or not the findings made could reasonably have been reached on sufficient credible evidence presented in the record at the time of trial. And they look at the proofs as a whole when doing so. And they always give due regard to the trier of fact who gets to see, hear, and observe the witnesses as to their credibility. The appellate court affirmed the decision. They did concur with the trial court that there was demonstrable objective evidence presented, in the sense that there was a pre-existing severe disability for which he already received an award. Petitioner complained of increase in not just subjective symptoms, but increase in pain, increase in range of motion deficits. But his doctor also corroborated those complaints. So it wasn't just a one-sided argument of, I hurt more, I can't do this, I can't do that. Well, the doctor also said on range of motion testing and other tests that he did at the time of the exam that he did find that there was more of a restriction. So it's not just complaints, which are purely subjective. So they upheld that decision. And basically, you have to look at the totality of the circumstances in these type of cases. Did the judge make a serious error? Is there evidence there to support his findings? Was there enough there to establish that there was an increase? You can't just appeal a case because you don't like the results. You have to make sure there's some type of an error. Either the facts aren't there, he applied the law incorrectly, something of that nature. Otherwise, unfortunately, you're just wasting time and expense to go to appeal on something that you just didn't like the findings, so let's appeal them.
Especially on, like you said, on the credibility cost. As Alan said, as long as there's evidence to support the judge's conclusions, the appellate division has always given deference to the judge. If there is not evidence to support the judge's conclusions, which you're going to be talking about later on, because we have a few appellate review cases to talk about today, and the reason we do is we want to give you an example of one extreme to the other, how much the appellate division stays hands-off on the judge's decisions on credibility costs, fact witnesses and medical witnesses. Who do they believe, who don't they believe? Legal issues, as Alan alluded to, are a totally different matter. If a judge makes an error of law, the appellate division, the gloves are off. The appellate division will absolutely look at an error of law. Here's the facts, that they apply the law correctly to course and scope of employment, independent contractor, jurisdiction. But in this case, the court found that there was enough evidence of a worsening of the condition. And as you alluded to, on a reopener application to review, he's already proven that he sustained an injury previously. He got benefits. He got a prior award of permanency. The only issue here is it worse? Okay. But adding insult to injury, they have a Section 20 resolved. It's ready to go. The guy's on the stand. The judge blows up the Section 20, finishes the trial, and finds an increase. And now they've got a new 2-year statute of limitations for reopener rights. But it gives you an idea that when we tell you that the judges are the final imprimatur of whether or not something's going to be approved or not, or settled or not, it doesn't matter that there's 2 attorneys that agree. The judge has to agree as well. A little bit, a lot frustrating for us a lot of times. Let's go to another course and scope of employment case. Again, similar to the previous one I was talking about, these cases, we need to keep these close by, because when you have similar cases pop up, if you know these cases, you'll more quickly answer the question about whether or not to admit or deny your case. So this is a parking lot injury case, and we probably get 2 or 3 a year. But how many parking lot injuries are there that happen every year? A lot. So when we get these phone calls, we're going to point to these cases, or at least review them to see how they apply to your case. In the Gould case, Ms. Gould is an LPN, and she falls in a parking lot after completing her shift at the County Correctional Center. And she worked at a variety of jails in New Jersey for Horizon Health. The facility was kind of a remote location at the prison itself. The parking lot was immediately adjacent to the prison and is enclosed by a fence. So right off the bat, you've got to understand that the idea of clocking in and clocking out is not relevant. She has clocked out. There is no doubt about that. She has left the building. The question is, has she left the employer's premises? And that's when we get to the premises rule. Horizon contracted for 24-hour per day medical services for the prison. So the question is, did her injuries arise out of and during the course of employment? And the holding in the case was yes, they did. And the reasoning was the parking lot was under the control of the employer because, first of all, obviously it's the prison parking lot, and Horizon is the 24-hour service provider to the prison. She doesn't have many options on where to park because it's such a remote location. She's got to drive to this lot, go through probably a protected fence, show ID, it goes up, it goes down. So there's so much control about where she parks as opposed to a multi-tenant building, multi-tenant parking lot. So they felt that her employer controlled the lot. I'm still not so sure I agree with the decision because Horizon is the employer, not the prison. I think the prison personnel would be covered, but I don't know that she should have been covered. But they felt that they slid the control aspect of the prison and the county to one of their vendors because Horizon is basically a vendor of the prison. But it gives you an idea of sometimes the liberality of some of these cases. But off-premises parking lot injuries have gotten somewhat better for us, but there has to be some control over where they park and limited access to getting in and out of work. And that was what they felt was important here.
Just remember three very important factors when you have a parking lot case. Does the employer own it? Do they maintain it? Or do they control it? If there's yes to any one of those three, chances are it's going to be found compensable. Not always, but most times they will be. The next case is another appellate review case, and in this one...
I give you all the appellate review
Yes,
cases.
we do. Yes, we do. And I've been to the appellate court once in 24 years, and luckily I won, so I'm batting 1,000. In this case, Longstreet versus County of Mercer, the workers' compensation judge found that an employee was involved in a compensable accident. The issue was compensability at the trial level. While plowing snow during the storm of January 2015, the trial judge found in favor of the petitioner and awarded permanency. At appeal, the appellate court reversed the trial court's decision, and they found this, and they came to this conclusion on the fact that the judge erred in a couple of very important ways. She made very specific findings of fact based on inferences. The evidence was not there for her to come to these conclusions. One, for instance, was that the plow he was using initially was damaged. He went back to turn that into the shop for repair. She made a conclusion that he took another plow out and continued to work, and that's when he suffered his injury, but there was no evidence presented at trial that a second plow was used. Nothing. The second was the location of the plows. They referred to the plow that he was driving that was damaged by two different names, the technical name of the plow that he drove, and then the number, 57. And they provided GPS data to show location. Well, the judge ruled, well, you provided data on number 57, but not on the second one that he used because of the technical term of that plow. And she concluded that the respondent didn't establish enough evidence to refute the fact that he was in the course and scope of employment when this injury happened. Well, obviously the appellate court ruled that there was enough mistakes made of fact and law that they not only reversed and remanded it, but they directed that this be heard by a new judge, feeling that the judge was prejudiced so much that she couldn't give a fair determination at retrial. And this is a really good case to establish the fact that if the judge doesn't find on the evidence that is presented in front of her and determine facts based on evidence that is there, that any person reading the record could possibly come to that same conclusion because the evidence is there, they will reverse the trial court. Perfect example.
Yeah. It gives you an idea. It can happen. It's just going to be rare. You have to carefully review the decision and the fact pattern to see if really they made that egregious error in reaching the conclusion. Next case we're going to talk about is injuries due to a physical altercation at work. This case, I don't know about you, but this case bothers me a little bit. It's just it's kind of unfortunate, the whole circumstance of it. The petitioner is a volunteer, he's a firefighter, volunteer firefighter, and he arrives at a facility for scheduled testing that everybody's required to attend. So when he gets to the facility, Mr. Y has Mr. X in a headlock. And the petitioner knows these gentlemen. In fact, some of them are related to one another. But he knows Mr. Y. Mr. Y is kind of a roughhouser. Maybe sort of not bullyish, but that kind of guy. Very physical, very aggressive, that kind of thing. So, and the petitioner's aware of this. So he decides to intervene, and he pulls Y off of X. Gets him to release the headlock. So what Mr. Y does is turns around and puts the petitioner in the headlock. Quick move. He gets.
Sounds like an episode of the WWE.
Something like that. So he does this, and he's squeezing the petitioner, and obviously the petitioner's head's down. He's losing some blood flow. He's getting maybe lightheaded. So he taps out. So I mean, when you hear tap out, they're roughhousing. They're just goofing around. Unfortunately, when he stood up, because he'd been in that headlock for a while, and maybe for other health reasons, who knows, he became dizzy. He fell over, and he sustained serious injuries. And so the question is whether or not the injuries are compensable. And what the petitioner testified to is he said at the time he pulled Mr. Y off of Mr. X, he's acting as a firefighter. He's protecting a fellow citizen firefighter. He's attempting to force the rules that the employer has in place for against horseplay. And he felt that Mr. X, who's in the headlock, was in some physical danger and he needed to help him. What was interesting and not surprising, I guess, terribly, is Mr. X and his mother both testified for the petitioner and said, hey, he did me a favor. I could have been seriously injured. I could have been hurt, because they feel badly. This guy's been that badly injured, really coming to assist him. So they testify for petitioner, but for not so much for Mr. Y, but for the county, other employees said it was just roughhousing. Mr. X was never in danger. It's just something that we do. We were just goofing around, wasting time until the session started. So we didn't feel the need to intervene. Only the petitioner did. There is, however, a written policy against horseplay. Not surprising, but there is a written policy. So, kind of a close call here. The judge listened to all this testimony, and she denied the claim. She said she was not persuaded that the petitioner's decision to intervene was in any way a serious rescue attempt. The actions were not mandated, compelled, or directed by the employer, and the facts didn't support that intervention was required. She said while his intentions may have been good, it was more than it was needed. Tough case. Sometimes I think of it as no good deed goes unpunished. And ordinarily, as we know, and you guys probably know, bad facts make bad law. And with the nature and extent of the injuries, the temptation to settle the case was probably pretty strong because he had pretty bad injuries. And it wasn't as if he was the one engaged in the horseplay. He was trying to break up the horseplay. So surprised at the decision. It's good for respondents, but it'll be limited to its fact. But I'm surprised at the ultimate decision.
I'm very surprised. I know a couple of judges I appear in front of that would have definitely found that compensable on the basis that he himself wasn't horseplaying. He was trying to assist a fellow employee. So, very surprised.
Surprise, surprise, another appellate review case.
All right. Then Artsdalen. In this case, the petitioner was involved in a compensable accident back in 2012 and received authorized treatment. The parties agreed to take the petitioner's testimony, submit the reports, not call any expert witnesses or lay witnesses, and let the judge call it. And they did exactly that. And at the end of the judge's review of the medical reports, the judge ruled that the petitioner established a 47.5% permanent disability. And that essentially, another thing that the judge concluded was that the condition was of such a nature that it was inoperable. It was so severe he could not submit to surgery. The issue was, in this case, was the judge's decision supported by substantial evidence in the record? The appellate court had found that there was not enough evidence and vacated the trial's decision, but remanded it back for further findings because they felt that the record itself was just lacking in what was needed to support the judge's finding. And in so doing that, the judge made a conclusion that the the trial judge, that is, made a conclusion that the condition was inoperable. The only problem with that is there was no medical evidence before the judge that would give the judge the facts and evidence needed to support his decision. It was more of an inference than it was an actual conclusion of fact and law. And so they just remanded it and said, present some medical evidence to support that conclusion. And in that respect, even though it wasn't crucial to the determination, it was a factor that needed to be clarified and amplified, and the record basically fixed and supported.
You know, what's interesting is that they're not going to give an opinion on disability rating. You know, the appellate division isn't going to say, hey, the judge found 47.5. We've read the record. It really is a 40. It's a 35. They're not going to do that, the appellate court. They're just going to simply either rubber stamp it and say there is sufficient credible evidence on the record, or in this case, she made findings of fact, he made findings of fact, where there is no evidence of record that supports something in the judge's decision. The condition was so bad, it was inoperable. There's no way to get it better. There was no evidence to support that. So they sent it back to the judge, but it's not as if they will now render a new decision on what's the level of permanency.
They just sent it back and said fix the mistakes, and they essentially did rubber stamp the percentage of disability, which is one of the big things that I always preach. When you're unhappy with the results of trial, especially with a how mucher, you have to have a really good issue of either error of fact or application of law to take it on appeal. Otherwise, you're just throwing good money in after bad.
Yeah, because in this case, talk about winning the battle and losing the war. They won the battle. Yeah. You were right. The judge's decision was incorrect on X, Y, and Z issues. And on remand, it's going to be the 47.5% with the corrected errors obliterated from the decision.
Fix your mistakes, and everything else is good.
Right. And how much costs were spent on the appeal, but they may not have had to pay petitioner's counsel's costs because the petitioner's counsel was not successful. Who knows? Because that can get expensive. They charge rates that are a lot higher than we do, and they put them on in the appellate documents so the appeal court can give them fees. All right. Let's talk about the statute of limitations. And I say here, once again, it's a winning decision. The reason I say that is this is the 6th or 7th case in the last 5, 6, 7 years of a winning decision in an occupational claim. Ordinarily, you don't think that as a respondent we can win these technical arguments, notice defense, statute of limitations. But when the facts are right, as in, again in this case, there's been a bunch of cases now. If the employee knows what they need to know to file a claim, and they don't do it within 2 years, they can be bounced from court with that technicality.
That's how it should be.
So here's the facts of this case. In Bender versus Township of North Bergen, petitioner files an occupational claim alleging work-related psychiatric disability, and the petitioner is a police officer, and oftentimes they may get the benefit of the doubt due to the difficulty of their job. And he testified he was exposed to gruesome assignments and trauma during his years of employment. And in 2002, he began to experience psychiatric symptoms, and he sought counseling with the police department, physician, and this treatment was continuous and frequent. So does he know that he's got a work-related psychiatric condition? Absolutely does. Of course he does. And so do they. He retires in 2004. If he files his claim by 2006, he's filed his claim timely. Instead, he files it in 2007. Why did he wait 3 years? Because at this point, the treatment has now ended. Because if it's treatment and it's authorized, it's paid for, it extends the statute. But the treatment has ended. He didn't get any more wage loss because he's resigned from the workforce, so he's not getting a temporary disability check. He's getting his retirement and pension. So he waits 3 years to file from the last time he gets a benefit and from his retirement date. And the question was whether or not the claim petition filed was timely. And the court's decision, both at the judge level and the appellate level, was it was not filed timely. That he knew everything he needed to know, at least by 2002 to file, certainly by 2004, and waiting until 2007 was too long. The sections of the statute that talk about this, Section 34 in the statute requires that the employee file the claim petition within 2 years from the date they discover the nature of the disability and the relationship to the employment. So applying the facts of this case, the petitioner was certainly aware of the nature of the psychiatric issues in relationship to the employment, clearly because he's treating with the counselors that made available by the police department. And our comment here is, with limited discovery in New Jersey workers' comp, we don't get to propound much discovery. Interrogatories are by statute, so they've been drafted by statute. Can we draft our own sometimes? We can. We do that. Oftentimes, petitioner's counsel will ignore it. We may have to get the judge to give us an order compelling our specific set of interrogatories in a certain case, and we will do that if necessary. But our discovery is very limited. We don't get to take discovery depositions. The only time these people, petitioners, testify is at the time of trial. We gather medical records, we exchange medical records, and our discovery is otherwise pretty limited. And the point that why I'm raising this point is, oftentimes we don't know if we have a statute of limitations defense until the petitioner testifies. Because when they testify, that's when they say, well, I knew I had this condition, and I drew the link to my job around this time frame, this year, this month, June of 2004. I kind of put it all together. The cases that have been decided in the last few years where the employers have been winning on the statute, oftentimes it's the judge who asks the petitioner the questions. And the petitioner will resist us because, we're the enemy. They're going to fight us on answers. They've been prepped to fight us on the answers. But when the judge leans over the bench and says, so you've had knee problems as a carpet installer. How long have you had those? Oh, for years, Judge. When did they start? About 2000. When did you think it was related to your job? I talked to my doc in 2003. We were pretty sure it was related then. Boom. It was filed in 2007. If I ask that kind of question, they're on their heels. They're very defensive. The judges ask, and oftentimes we get those helpful answers. But it's interesting. You don't get the statute of limitations defense sometimes until you're in trial.
I think more often than not, it's the time of trial we find out. Oh, look at this, another appellate review.
At least this is more course and scope, right?
It is true. This is a very good one. I like this one. In this situation, the petitioner is another police officer, and he goes into the police station to pick up his check, but also to check his calendar to see if he's scheduled to appear in court at any time during the next week. And the petitioner and two co-employees testified at trial that this was an ongoing disciplinary problem. They had merged two townships together into one municipal court. So a lot of police officers were actually missing court dates and getting disciplined for not being in court at times that they should have been, because if the witness isn't there, the judge has no choice but to toss the charges, and they get away without paying their fines that they should have. The defense argued that he didn't have to be there. He went there just to pick up his check. He could have checked his calendar at any time during the week when he was on duty, but he chose to go there on his day off to check his calendar. And after he had done that, left, he fell in the parking lot and injured his shoulder. The trial judge concluded that the petitioner wasn't required to come in, which is true, on his days off. But because he was checking his calendar, because he was being diligent to make sure he didn't miss calendar date, that there was a benefit to the employer. He was being diligent, trying to do his job. There was a mutual benefit for himself to make sure he's doing his job right, to the employer so he doesn't miss a court date and they lose revenues in the municipal court. So the issue here was the injury suffered in the course and scope of employment? And of course, it also has an appellate review aspect to it as well. And the appellate division affirmed the trial court's decision, finding that the petitioner's injury did occur within the course and scope. And in doing so, they reasoned that the actual determination by the trial court was supported by substantial credible evidence in the record, and that he didn't miss the mark so wide that it was manifestly unjust. There was an egregious error done. There was a mutual benefit. He went there on his time off. He was a little diligent, maybe a little anal. He wanted to make sure that if he's scheduled to be in court, he doesn't miss that date and get disciplined. Because apparently several officers were severely disciplined because it was becoming a really bad issue with a lot of them missing court dates. So in this situation, you have to look at the facts. Is there a benefit to the employer? Yeah, he went in to pick up his paycheck, but he also checked his schedule. He made sure there wasn't any court dates that he wasn't aware of or didn't write down on his calendar. So there was a benefit to the employer, and in doing so and in finding that benefit, the courts decided it was in course and scope. He wouldn't have been there, or maybe he would not have been there, but for the fact that he wanted to make sure he didn't make the mistake that other officers were making and missing a trial date.
I talked to one of the defense attorneys that worked on this case, and they said that the facts were really trumped up in order to find compensability. That this guy was all over his calendar, always knew what was going on. Something about it, he either had access on his phone, he had never missed a date. the glitches had been worked out long in advance, and there's no way this guy would have been due in court for another week or two, and he had multiple days of work in between where he would have been able to check. And they said this was really a social visit, and they just turned it into a compensable event. So
they're always gonna help police officers. Never want one of them to get hurt and not get compensated, unfortunately.
It makes it difficult when he's on the employer's premises, even though it wasn't during work hours. And he was able to build a little pretty easily by saying to check on the calendar. But the facts were that wasn't necessarily the case at all. But anyway, I'm going to talk about a temporary disability case, and I'm happy to talk about it, and that's why it hit one of our top 10. Because it was, even though the facts in this case are kind of unique because it involves a firefighter, so not a lot of us handle municipalities and volunteer firefighters in those cases, so the facts are very unique. But the decision itself went over thoroughly defenses to entitlement to temporary disability benefits than I haven't seen in quite a while. So it's a really good summary of the law, and I'm going to talk about it a little bit in some of the PowerPoints. So anyway, in this case, Kokanowski, she is a volunteer firefighter. And on March 6, 2015, she suffers multiple leg injuries when she's doing her job duties. She gets medical treatment and permanency without any defense or any dispute. They don't dispute that she's entitled to those two benefits. What they do dispute is whether or not she's entitled to wage loss benefits. And the reason they dispute it is at the time of the injury, she was not employed anywhere else. So the county took the position that, we appreciate what you're doing as a volunteer. We'll take care of you medically and you get a permanency award. But there are no wages to replace. You weren't working at the time you were volunteering. And frankly, when I first heard about the issue, I thought I wasn't sure that volunteer firemen didn't get paid whether or not they were at a job, because they get tons of benefits under the statute. Maximum rate, for instance. It doesn't matter what their wages are elsewhere. If you're a volunteer fire person, and if your full-time job is $400 a week, you don't get $280. You get the maximum, $843, $896, whatever the year is. So in this case, the facts were that she's injured in 2015, but she had not been working nor looking for work since 2013. Now the facts get even more, laudable or praiseworthy for the injured worker. Part of the reason she hadn't been working is she was at home taking care of her ailing father. So she's not working to take care of her ailing father, but she's still doing her volunteer firefighting. Seems like a pretty nice person. Her license as a certified home health aide had expired because she took time to take care of her ailing father. So the question is whether or not she's entitled to temp, and the judge said there is no entitlement to wage loss benefits, and this was affirmed on appeal. What the petitioner argued was volunteer firefighters get certain benefits under the statute, and they're like, there's no waiting period. There's normally a 7-day waiting period for everybody else. There's no 7-day waiting period for a volunteer firefighter. It doesn't know how many days. You don't have to be out a certain number of days to get your temp check. But what the appellate division said was there has to be wages, temporary disability are replacing current wages. And actual absence from work is a prerequisite to an entitlement to temp. The petitioner must actually have a loss of income because of the disability, and otherwise it would just be considered a windfall. So some of the, again, she made her arguments about the beneficial treatment provided to volunteer firefighters, but the judge in the appellate division rejected those arguments. And the court looked at some other cases, and this is a quick little summary of those cases. For instance, the 10-month salaried teachers, are they entitled to wage loss during the summer months? And the question is maybe. If they normally work during the summer months, and they can prove that they always work during the summer months, they're entitled to wage loss during those other 2 months. If they take the summer off, they're not entitled to wage loss checks because they got a 10-month salary. So they get their wage loss checks during those same 10 months, but not in the summer when they weren't getting the check anyway. Otherwise, again, it would be a windfall. Full-time college students. It's an old case from 1973, but it's still good law. The idea being if you are pursuing full-time courses, you're taking yourself out of the workforce. You can't pursue a job if you're going to class full-time, and that's defined as at least 12 credits. I've used that argument a few times in some big cases I had for one of our bank clients. And the person had been injured, was out of work for a while. We found out they were going to school. We got the transcript, and we suspended the benefits. And they argued against it, saying, well, they're still treating. And my judge had no problem saying, full-time student, not entitled to temp.
And in that instance, you actually have to show that they worked at night. For instance, if they argue, well, yeah, I went to school full-time, but I also worked at night. They'd have to come in and provide evidence that they actually held a full-time employment while going to school full-time.
Okay. And those individuals that voluntarily terminate their employment, they're not entitled to wage loss. They remove themselves from the workforce and from steady income. So if their disability recurs for some reason, they're not going to be entitled to wage loss again. So it's a good review of some of the temp issues that we have out there.
And I just had a case like that Friday, where the lady got injured back in 2010, serious injury, at least 2 surgeries. She was running her own restaurant, and after she settled her case and all her injuries were resolved, she decided can't work anymore. The fact that she was in her late 70s, of course, was one factor, but she was going to sell the restaurant. Now, she didn't sell the restaurant, but she didn't run it anymore. So she took herself out of gainful employment, didn't work, and this past Friday they filed a motion for Temp, just Temp, asking for wage loss benefits because of the surgery she recently had for the knee replacement. Took her out of the workforce. She couldn't work even if she wanted to. But my argument was, Judge, the statute says wage loss. If wages aren't lost, you don't get Temp. And I was right. We won that one.
Yay! Every once in
a while, blind squirrel finds a nut.
All right, well, we did 10 cases, but we have a stocking stuffer bonus. That
I love this one.
Alan did it for us.
This is one of medical provider CPs, which we are seeing all the time. In this case, the University Physicians Associate versus transport drivers. The facts: petitioner was involved in a compensable work accident, suffered injuries to his hip. Dr. Livingston performed the hip replacement, billing $10,343. Dr. Abrams, his partner, did the open reduction and internal fixation, billed $71,374. Both doctors billed their services at the 95 percentile, and the carrier paid Dr. Livingston $3,788.98 and Dr. Abrams $24,238. The carrier paid at the 75 percentile. The trial court did not find that the medical provider's witnesses were persuasive and basically found that the carrier's payment at 75 percentile was appropriate. On appeal, the issue was how to determine usual and customary in auditing medical bills. And I see this all the time. They come in, counsel for the medical provider, but everybody else bills $150,000. Therefore, that's customary, that's reasonable. They should get paid $150,000. Bottom line is the Appellate division said no. They made 2 conclusions that are important here. Number one, the Medical Providers Council was arguing they're a level 1 trauma center, and therefore they are exempt from these different levels and different percentiles. The court said no, you have to look at a doctor, the treatment provided, and what do they get paid. Number 2, which is part of what I just said, it's not what they charge, it's what they accept as payment in full, which is how you determine customary reasonable charges. I've been arguing that for years, and finally we have a case right on point. They don't look at what they charge. Just because they charge $1 million doesn't mean they're going to get paid $1 million. It's what they accept, or what others in that field will accept as payment in full, is what determines customary and reasonable. This is going to be very helpful in the future.
It was a good case because the only other one we had before this was the St. Barnabas case that Judge Dietrich rendered, and that was a monster decision and awesome decision by Judge Friedman, Judge Dietrich. She really went through the facts and the law thoroughly. But this one is a little bit more easy to get your hands around, and we have more quotes and more things to rely upon, including. It was interesting that the doctor testified on behalf of his bill. He didn't have his billing clerk testify or an accounting person. He actually testified himself, and the judge found that the accounting person for the medical payer vendor was more credible because of the systems that she used and the various medical pay, databases that she used to average out what was the correct average payment, as Alan said, not bill. What do you accept as payment? Because if it's what you bill, then you decide how much money you make and how much you charge. It's how much do you accept on payment, and it's usually somewhat of an average of PIP and Geico or various carriers, whether it's health carriers, Medicare, Medicaid. It's sort of a cross section, is what we try and argue in our cases, and that's pretty much what the court concluded.
And I agree with you. I think the biggest factor was that they came in and they provided evidence, not just what people charge, what medical providers charge in that area, but what they accept as payment in full. And that's really the determining factor on what's customary reasonable. What they accept as payment in full, not what they charge.
All right, well, thank you for your time today. Hopefully we didn't take up too much of it, a little bit longer than I thought. Remember, if you have any questions about any of the issues that we discussed today or anything else about New Jersey workers' comp, feel free to email us at questions@wglaw.com. So we're preparing our 2018 agenda. That's going to be circulated soon. We're going to have, at a minimum, we're going to have 12 webinars in 2018. The plan is to have both on a rotating basis, Pennsylvania, New Jersey, and Delaware. And as things come up, we will have impromptu webinars anytime, like we did in 2017 when the Supreme Court of Pennsylvania came out with the Protz decision. Our partners over in Philadelphia had a webinar within days to give you updates on what Protz, what it said, what it meant, and the implications for you. So we'll keep doing those for you as well. Again, thank you, and everybody have a great holiday.
Take care.